Madam Secretary, on April 24th, a woman in Louisiana was deported along with her 7-year-old daughter and 4-year-old son, both of whom were U.S. citizens. The 4-year-old son had stage 4 cancer. Now, you just stated under oath that the mother consented to having her U.S. citizen children removed. But I have spoken with the attorney for that U.S. citizen child with stage 4 cancer. She has also made numerous statements to the press in which she stated unequivocally that at no time did the mother consent to her U.S. citizen children being removed. What evidence do you have to support your claim that she did consent?
Congressman, we followed the same policies and procedures.
What evidence do you have?
And we
what
have
evidence do you have?
We have documentation that
what documentation do you have that mother consented?
We will get that to you, sir. I don't have it with me.
Please do. I understand it's hard to keep them all straight because you've deported multiple U.S. citizen children, but I'm asking specifically.
A congressional hearing turns tense as lawmakers confront the administration over the deportation of U.S. citizen children, including a 4-year-old with stage 4 cancer. What unfolds is not a policy debate, but a stark examination of whether immigration enforcement ignored the law, court rulings, and basic due process protections.
Specifically about the 4-year-old with cancer who was deported on April 25th. For the record, that family was also not given access to legal counsel before they were deported, even though their lawyer was in the same building at the time. I'm holding in my hands here a document called ICE Directive 11064, Interests of Non-Citizen Parents and Legal Guardians of Minor Children. This is the policy for how ICE agents should handle situations like this. It states unequivocally that parents and legal guardians should have the ability to make alternative care arrangements for minor children prior to their arrest or detention, and that ICE must afford parents the opportunity to consult with legal counsel. So, did the ICE agents working on this case who deported this 4-year-old with cancer of their own volition fail to follow ICE policies, or were they directed to by your office or anyone else in DHS leadership?
Sir, this mother chose to keep her child with her.
You have not produced any evidence to say so, but I'm asking again, have you directed DHS officers to ignore this
It's
policy?
very different than the previous administration. The previous administration
on March 15th, reclaiming my time, on March 15th, your department sent 3 airplanes to El Salvador. Those planes carried approximately 261 individuals who were imprisoned upon arrival. Did you personally review and approve the names of those 261 individuals before they were sent?
Sir, we have deported and sent home
did you review the names of those individuals?
And we have individuals that have
why won't you answer the question?
Within the Department of
Are you
Homeland
aware
Security.
of whether those 261 individuals were given the opportunity to speak with a lawyer or appear before a judge before they were put on those planes? Yes or no?
Sir, every single individual followed the exact same process.
They were not all given the opportunity to appear before a judge or speak with a lawyer. On April 7th, the Supreme Court ruled that detainees must have an opportunity to have a hearing before they are deported. Are you familiar with the April 7th Supreme Court ruling?
I am.
Can you assure us that in the future you will abide by that Supreme Court ruling to provide detainees with a hearing before they are deported?
Following all judges' orders, yes, sir.
I have a photograph here of André Hernandez Romero, a gay makeup artist from Venezuela. He fled Venezuela fearing gang violence because of his opposition to the Maduro dictatorship and his sexual orientation. He presented himself at a port of entry and requested asylum. His claim was found to be credible, and he was placed in detention to await a full hearing. But he never received a full hearing because you put him on one of those planes to El Salvador, where he still is today. Listen to me. He had no criminal record in the United States or in any other country. He did not even enter the country illegally. He presented at a port of entry. He tried to do it the legal way, and to this date, the only evidence your department has presented to justify his imprisonment is that he had 2 tattoos, one that said mom and one that said dad. Do you have any other evidence to present for why this individual should be locked up in El Salvador?
Sir, every case is used the same protocols and the same processes and inputs.
Do you have any evidence other than the tattoos that say mom or dad for why this individual should be locked up?
So it's not just on tattoos. It's who they're affiliated with, their communication.
You have not presented any other evidence, nor has your department. Reclaiming my time, during your confirmation hearing, you said your focus would be on deporting immigrants who have been convicted of crimes and those who have received removal orders. But that is not what you have been doing. Instead, you have been deporting children with cancer, children who are U.S. citizens, a gay makeup artist who committed no crime and didn't even enter the country illegally. You have been sloppy. Your department has been sloppy, and instead of focusing on real criminals, you have allowed innocent children to be deported while you fly around the country playing dress up for the cameras. Instead of enforcing the laws, you have repeatedly broken them. You need to change course immediately before more innocent people are hurt on your watch.
Gentleman's time has expired. I now recognize...
This script captures a powerful and deeply consequential exchange between Representative Seth Magaziner and the Secretary of Homeland Security over a series of immigration enforcement actions that raise serious legal and moral concerns. At the center of the hearing is the deportation of a woman from Louisiana along with her 2 young children, both U.S. citizens, including a 4-year-old battling stage 4 cancer. The administration claims the mother consented to having her children removed from the country. Magaziner challenges that assertion directly, stating that the child's attorney has repeatedly and unequivocally denied that any consent was given. When pressed for evidence, documentation, written consent, or any contemporaneous record, the Secretary cannot provide it, promising only to supply it later. That absence becomes critical because consent is the legal hinge on which the entire action rests. Without it, the deportation may have violated both constitutional protections and ICE's own policies. Magaziner then introduces ICE Directive 11064, which clearly states that non-citizen parents must be given the opportunity to consult with legal counsel and make alternative care arrangements for their minor children prior to deportation. According to the facts presented, the family's attorney was physically present in the same building at the time, yet the children were deported anyway. If accurate, this is not a matter of discretion. It is a failure to follow binding policy. The hearing expands beyond this single case to reveal what Magaziner argues is a broader pattern. He questions the administration about multiple deportation flights to El Salvador carrying hundreds of individuals, asking whether detainees were given access to lawyers or hearings before removal. He references an April 7th Supreme Court ruling requiring the detainees be afforded an opportunity for a hearing prior to deportation. While the Secretary claims compliance with court orders, she provides no specific assurances that these requirements were met in the cases discussed. One of the most striking examples involves Andre Hernandez Romero, a Venezuelan asylum seeker who entered the U.S. legally through a port of entry, passed a credible fear screening, and had no criminal record. Despite awaiting a full hearing, he was deported to El Salvador and imprisoned. When asked to justify this action, the only evidence cited involves 2 tattoos reading Mom and Dad. No additional evidence of criminal activity or gang affiliation is presented on the record. Magaziner contrasts these outcomes with the Secretary's confirmation testimony, in which she stated her priority would be deporting individuals convicted of crimes or already subject to removal orders. He argues that instead, the department has acted sloppily, sweeping up innocent people, including sick children and lawful asylum seekers, while bypassing due process. The script concludes by emphasizing why this exchange matters. Immigration enforcement is not solely about border control. It is about adherence to process, law, and constitutional protections. Due process exists precisely for moments like these, when government power is at its greatest and those affected are least able to defend themselves. Oversight hearings, the script argues, are not political theater when they force facts onto the public record. The unresolved question is whether those facts will prompt accountability and reform, or whether these cases will be dismissed as acceptable collateral damage.